Wow, this is a great group. Thank you all so much for joining us. I appreciate it very much. My name is Erik Arneson. I'm the Executive Director of the Office of Open Records. This is our annual training. For the first time ever, it is entirely being conducted online. We've had this as an option in the past, but this is the first year that we've done it entirely that way. And thank you for being a part of it. We have some great speakers today. The lineup includes representatives from the Office of Open Records, which our annual training always does, but this year we've also got some terrific input from other places, other sources. Tom Howell from the Commonwealth will be here. Scott Chadwick, representing the Pennsylvania State Association of Township Supervisors, is going to speak, as is Melewsky of the Pennsylvania NewsMedia Association. Mike Krimmel from the courts was scheduled to join us. Unfortunately, Mike wound up not being able to be here today, but we will miss him, but we will proceed and do what we can without him. I'm going to say a few words here at the very beginning, and then we will get into the main program. All right. This is, as I said, our first annual training that's being conducted by Zoom. Please be aware that we are recording this session. We plan to post it to YouTube. Everybody is muted, so you shouldn't be able to accidentally say anything, but please do be aware that this is being recorded for future posting to YouTube. If you'd like to submit questions to the panel, you can use the Zoom chat tool. You can also email us at the email address that was included in this morning's notification email. You see that email address there as well. It is also at the bottom of every slide. The print is a little bit small, but it's there. It's ra-dcoor.training@pa.gov. We will answer as many questions as we possibly can during today's session. We are scheduled to go for 2 hours, and we will not go longer than that. But if we aren't able to get to your email or your question in that time frame, don't worry. You can simply email us at openrecords@pa.gov after this discussion ends, and we will get back to you that way. Unfortunately, CLEs are not available for this year's annual training. We ran into a bit of an issue with some changes that appear to have happened with the Bar Institute and the Bar Association, and weren't able to make that happen this year. Hopefully we will be able to do so again next year. The Right to Know law went into effect on January 1st of 2009 in Pennsylvania. Since that time, the state has not faced anything even close to the pandemic in terms of its effect on many things, including the Right to Know law and the Sunshine Act. Of course, there have been some localized short-term emergencies, mostly snowstorms and floods, things along those lines that caused some issues for some agencies. But the pandemic has caused issues all across the state, again, including the administration of the Right to Know law and the Sunshine Act. The OOR has worked to provide what we hope are clear and helpful advisories to assist agencies and requesters as they navigate these challenges. Overall, from my perspective, and I'm asked this question periodically, overall agencies and requesters have responded very well to the challenges presented during the pandemic. Some challenges, of course, continue even today, and we're going to talk about that a little bit more. The OOR recently conducted 2 surveys. Both of them were focused on how the pandemic affected the administration of the Right to Know law and the Sunshine Act. One survey was designed for agency open records officers, and one survey was designed for requesters. Of those surveys, we received 377 responses to the ARROW survey and 26 responses to the requesters survey. Obviously, more responses are always better. We appreciate everybody who did respond to those surveys. and we're going to talk about them a little bit here at the start of today's presentation. The full results will be available later this week at the Office of Open Records blog, which is available at openrecordspennsylvania.com. The presentation I see in the chat, there's a presentation, question about this presentation, and I do apologize. The presentation is not currently available. It will be available for your review. I will make that available on the Office of Open Records blog later today. I apologize that I didn't get that done in advance. In the Arrow survey, of those 377 responses, the plurality, the most were from townships. We also had a lot of school districts and boroughs respond. Commonwealth agencies responded as well. The agencies under the governor's control made a joint submission, which we very much appreciate. So there was terrific participation by Commonwealth agencies. And then others, charter schools, police departments, authorities, intermediate units, just about any kind of local agency that you can think of, at least a few participated in that survey. One of the questions we asked was, during the COVID-19 emergency, has your agency seen a change in the volume of requests you have received? The biggest response here was that there has not been any change, and that's about 67% of the agencies. Now, I want to take just a minute to remind you that many agencies, there are about 6,000 agencies in Pennsylvania. Many agencies see very few right-to-know requests during a regular time period. So I think it is significant that 67% of agencies are reporting that they saw no change, but it is also possible we would need to do further analysis that we haven't had time yet to do to see how many of those agencies generally receive few requests in a normal time versus many requests. And then you can see as well the number of agencies who saw a decrease in requests versus an increase in requests are roughly the same, roughly 15 to 17% for each of those categories. During the COVID-19 emergency, has it become harder to fulfill right-to-know requests your agency has received? I don't think there's any surprise here on that bottom category. Nobody said it was easier. 2/3 of agencies said it was the same, but that leaves a lot of agencies who said it was somewhat harder or significantly harder. So as you would expect, the pandemic has caused challenges for agencies as they work to fulfill right-to-know requests. During the COVID-19 emergency in general, have you provided responses to right-to-know requests much more quickly? Again, I don't think there's any surprise. No agency reported that. A few agencies did report that they are responding more quickly. Most, again, about the same. 82% reported that their response time is about the same. And about 17% of agencies said either less quickly or much less quickly. Other highlights from that survey, and I know this is a lot of numbers to throw at you, but 68% of agencies never found it necessary to change their right-to-know procedures during the pandemic. Only 5% of agencies said that they have seen more appeals during the emergency. Remember the key difference between requests and appeals. 5.3%, which is not a big number, but 5.3% said they experienced difficulty participating in an appeal. That's something that I think we, the Office of Open Records, need to look at on our end and see if there's anything we can do to make that process better. In terms of the Sunshine Act, 70% of agencies reported using Zoom or a similar service to host public meetings. On this question, they could choose more than one answer, so that's why these numbers total more than 100%. But 70% have used Zoom or another video conferencing technology. 54% have continued to hold meetings indoors, but reduced the capacity of those meetings. About 20% used a telephone-based system, and 7.3% held meetings outdoors, which is interesting and a little bit, for me anyway, unexpected, but I like that answer quite a bit. On the requesters survey, we did only have 26 responses, so I don't think that any broad conclusions can be reached here. It's always more challenging for us to reach the requester community. We have a terrific database of agency open records officers, and so it's easy for us to contact them by email. We do have a semi-regular email newsletter that we send out, and I used that to help spread the word about these surveys. Requesters can and do subscribe to that, but still, it's a challenge. I should also say thank you to the NewsMedia Association, who helped spread the word about the survey as well. So, of these 26 responses, I do still think there's some interesting information to be gleaned here. You can see there the breakdown of who those 26 respondents were. And we asked them during the COVID-19 emergency, have you received responses more quickly? Nobody said they've received it more quickly. About the same was only 23%, and less quickly was basically 77%. So a little bit different than the answer we saw back from the agency open records officers. But I do think it's a good conclusion that these requesters who were able to spend time answering our survey and had the interest to answer our survey probably are more active requesters than the average. So this is what regular users of the right to know law, those who responded to the survey, are seeing. We asked requesters, since all counties entered the green phase in May, how often have you received a timely initial response to your requests? Here the numbers are a little bit better, about as often as before, said 56% of requesters. More often, 4%. So some requesters are seeing it happen more often. And then less often, the remainder, about 40%, are seeing less often a timely initial response to a right to know request. We asked if they have submitted more appeals or fewer appeals arising from right to know requests during the COVID-19 emergency. Here you can see 37% said they have submitted more appeals. And this is part of the reason that I think it's fair to conclude that these are more active than average requesters who responded to the survey. 54%, about as many, and about 8% said they have submitted fewer appeals. We asked them if they sought to attend a public meeting during the emergency, if they encountered any issues that prevented them from doing so satisfactorily. 48% said more than once, 16% said once, and the rest either have not attended a public meeting or said no. So that's about 64%, nearly 2/3, who've experienced some kind of issue. We didn't dig down, unfortunately, and ask what the issue was, but I think it is worth noting that even though technology has helped agencies comply with the Sunshine Act during this time, that there are still some challenges here, and the public does experience difficulty with that. So it is something for agencies to keep in mind and continue working on ways to try and make it a smoother process where they can. And finally, a few other highlights from the requester survey. 43.5% encountered issues trying to comment at a public meeting, and I think that's what we received the most. I won't say the most. George Spiess is going to speak next, and he'll talk about the Sunshine Act, but we received a lot of questions from the time of the pandemic first started through the summer, from people who wanted to comment at public meetings, from agencies who wanted to make sure they were allowing public comment appropriately. We got a lot of questions about public comments and the Sunshine Act during the pandemic, using Zoom, using other tools to do that. 17.4% of the requesters felt that safety measures at a public meeting they tried to attend or attended were insufficient. 29% of requesters encountered issues communicating with our appeals officers. And that, again, is something that we need to definitely take a look at ourselves at the Office of Open Records, see what those issues are and how we can help resolve them, because being able to communicate with the appeals officer, we want that to be as friction-free as possible. And again, with the Sunshine Act, 55.6% of requesters submitted public comments by email. And this, again, was a question where you could choose more than one answer. Another 40% participated via video conference. 1/3 called in and participated that way, and 22% participated in person. And so, there we go. That's my introductory comments here. Please do ask questions in the chat. I might be able to answer some of them as the presentation goes, depending on the nature of the question. We will ask as many as possible of the panelists. And just to give you a sense of the order here today, up next is George Spiess. He'll talk about the Sunshine Act. Delene Lantz, our General Counsel at the Office of Open Records, will then talk about a number of issues the OOR faced during the pandemic, including our mediation program and others. Nathan Byerly, Deputy Director of the OOR, will talk about the advisories we issued and how they came about and what role we think they'll play in the future. Tom Howell will talk about issues faced by Commonwealth agencies, and I think they tackled a lot of significant issues during this pandemic. So I'm looking forward to hearing from Tom. Melewsky will talk about a requester's perspective. She's with the NewsMedia Association. She's their media law counsel, and she'll give us that perspective. And Scott Chadwick will give us the perspective of the State Association of Township Supervisors. And I think townships, by number, they're the biggest group of local agencies. They vary in size quite dramatically, so I think they have a good set of experiences for us to learn from. And then closing out the session will be our Chief Counsel, Charles Brown, who will talk about case law. And after that, we will have time for questions and answers. We might work some questions and answers in between as well, but we may, depending what they are, save them for the end. And with that, I will turn it over to George Spiess. Thanks, George.
Thank you, Eric, and good afternoon, everyone. Glad to be here. I'm going to spend the next couple minutes talking about the Sunshine Act as it relates to the COVID-19 disaster, and primarily from the agency perspective. One of the things that I want to emphasize here, and this point still comes up, is that nothing has happened to suspend the Sunshine Act. It never went away, and agencies have the obligation, to the best extent possible, to conduct official business in public, just as they've always had that obligation. What is different with the emergency declaration and the passage of what we call Act 15 of 2020, which primarily refers to emergency services, is that it emphasized the fact that during an emergency declaration, agencies can set aside certain processes and permit modifications to those provisions to ensure the health and safety of the community, of their board, and of their employees. So where that leaves us is that using language out of that act, the term practicable, is that to the best extent practicable, agencies must adhere to the Sunshine Act. And from my perspective, there are three key elements that you need to keep in mind that must be met. First is advanced notification of the scheduling of meetings. If you recall, with the Sunshine Act, any regular business meeting, you need at least 3 days advance notice. Then the second element would be that public participation or observation is required. And then finally, public comment, as Eric mentioned, as one of the issues. So, how do we do that? And like I mentioned, under Act 15, it's to the best extent practicable. And I think it took a while to figure this out. And initially, we were even saying to agencies, do you really need to have a meeting this month? Until we kind of figured out what was going on with the emergency declaration with the COVID crisis, we weren't sure whether it was going to last 2 weeks or as long as it has. So I think initially there were many agencies that simply canceled their meetings because they had no pressing business that couldn't wait a month or two until we got things sorted out. But I think the response has pretty much been to use some sort of electronic platform, whether it be Zoom, Skype, Teams, some of the other software packages that are out there. If agencies were not able to post advance notice in a paid newspaper of general circulation as is required under the Sunshine Act, many resorted to the next best thing, which would have been using their websites to put notification out there that meetings were coming up. I didn't hear a lot of concerns over not being able to post notices in newspapers. What I sense happened was not only was there notification in newspapers, but in addition to that, because of the unusual circumstances, agencies were also embracing social media to get the word out there about these electronic meetings. So we kind of got the best of both worlds. And if anything, we probably saw an improvement in the level of notifications that were taking place as a result of embracing technology. We also recommended posting advance notice of agendas on websites, which is something that is not a requirement of the Sunshine Act. Periodically, we will get questions about agendas related to the Sunshine Act, and I have to respond back that the Sunshine Act doesn't speak to the world of agendas. But what we did see is as a means of better public service, as a means of better customer service, many agencies started doing that in order to be prepared and to have the participants better prepared during the electronic meeting. They were going above and beyond and posting agendas on their websites, on their Facebook pages, tweeting them out ahead of time. And I think, if anything, that is a good thing. And we've had a couple questions about, can we keep on doing this after the emergency declaration has expired? That remains to be seen. Obviously, it's not within our jurisdiction to have any say over that or have any control over that. But many agencies want to embrace these electronic meetings moving forward, which I think is an interesting offshoot and probably a discussion for another day. Another thing that we've seen is the recording of these meetings. When this started out and we posted our advisory, actually, which preceded the passage of Act 15, we recommended that whenever possible, agencies record their public meetings and then make those recordings available to the public, whether it be through posting them on a website or simply having them available to copy through electronic means of some sort. And that seems to have worked out rather well for those agencies that have embraced that. So in order to meet the spirit of the Sunshine Act during the emergency declaration with the limitations that many agencies have had to face, it's also created a number of opportunities. So I think we need to look at it from that perspective as well. And, if you think about this, since March, since May, there have been literally thousands of meetings, public meetings held online that have been successful and without any sort of disruption, whether it be to, we had some isolated instances of meeting hacking, and, still to this day, we'll get reports of electronic meetings where there was just some technological glitch that resulted in, maybe participants couldn't hear what the board was saying or vice versa, issues with public comments and the like. And I'll speak to that in a few moments. But I think, as Erik indicated from the results of the survey, overall, it's been rather successful. And I think it becomes a matter of the users being familiar with the technology that they're using in order to broadcast these public meetings. It took us a little while to figure out all of the bells and whistles in Zoom when we started using it for internal meetings within the Office of Open Records. And it's worked out really well with minimal disruption, and I think that's what most agencies have experienced. So what are the current concerns here as we're continuing on with the emergency declaration, and we're seeing an uptick in the infection rates, which very well could lead to going back to some of the limitations that we experienced initially when the emergency declaration was put in force. I just got done talking about online meetings with technical glitches. And I think that bears being addressed here because I had just this issue came up just the other day with a caller where there was an online public meeting, but due to a technical glitch, the public participation aspect of that meeting was not successful. Something happened that the participants who were logged in weren't able to hear what was going on, and they weren't able to ultimately comment on any action being taken by the board. In this instance, the board was not aware of the technical glitch, so they proceeded on with the meeting. It is possible that one could argue that because of that, any action taken would have represented a violation of the act. Now, it's not up to me to declare whether or not it was a violation. Obviously, if you're familiar with the act, someone would have to allege that there was a violation and take it to their county court of common pleas if that's the appropriate venue. I think in this case, though, and in similar cases, it is incumbent upon the agency to more or less do a do-over. Under normal circumstances, if something were to happen that the public could not participate, then at that point, I think it could be argued that it would have been appropriate for the agency to suspend any further action. In this case, since they weren't aware of the technical glitch, I think it's incumbent upon them to go back and do a do-over. If you're familiar with the Sunshine Act and appropriate case law, agencies can cure violations or alleged violations. And in this instance, that do-over that I'm using that term for would cure any alleged violations, which would be represented by a vote taken where the public would not have been given the opportunity to comment or even, witness the vote online. But let's say that hypothetically, the agency would have been aware of the technical glitch. I think at that point, when they were made aware of the fact that the public could not participate or could not comment, then I think it was incumbent upon, or it would be incumbent upon the agency to suspend the meeting at that point. And until the technical glitch is resolved, not to take any, or not to have any deliberation or make any decisions in the form of a vote at that point, if they know that the public is unable to participate. The question has come up recently about, can an agency require the public to wear masks at in-person meetings? My perspective is that yes, that's appropriate. All throughout the emergency declaration, when we were doing the COVID-specific webinars, and since we suspended that and went back to our regular schedule, when we do the webinars on the Sunshine Act, this will come up. We emphasize that the safety of the public, the safety of the board, the safety of employees is paramount. And while you have an obligation to conduct business consistent with what the Sunshine Act says, public safety, I believe, takes precedent. And I think requiring the public to wear masks at a public meeting is a prudent step that you can take that you can certainly justify given where we stand with the COVID crisis. And I think it's a reasonable expectation. And if you've got a member of the public who refuses, it's a matter outside of the Sunshine Act, but you would take whatever appropriate steps you feel are necessary to resolve that conflict. And then finally, one that is somewhat troubling is that we've had some reports of people being turned away from in-person meetings due to physical distancing limitations. Typically a conference room may be able to hold 30 people. Due to social distancing requirements or limitations, now that room may only have a capacity for 15. Well, what happens to the 16th person that shows up for that meeting? We've had reports of them being turned away, being told that they cannot attend the meeting. I would say that's unacceptable, and that the agency has an obligation to address that immediately. Just as if prior to the COVID emergency declaration, if you had, if you have a conference room with a capacity for 30 people and 31 show up, you would have a problem turning away that 31st person. So whether it be what many agencies have done is embraced hybrid meetings, where, yeah, there is an in-person live meeting, if you will, but it's also being video streamed so that, people can participate both in person and electronically. I think we've been in this long enough that most agencies should be aware of what electronic platforms are available for them to use and how to successfully use them. So the idea of turning people away from a public meeting just should not be happening at this point. And if you are there, I would argue that that's unacceptable and that you're really opening yourself up to some sort of liability. So those are the main points that I wanted to cover, what we've experienced thus far, and kind of what we see on the horizon as we work our way probably into a season where we're seeing an uptick in the infection rates, but also ultimately some light at the end of the tunnel where we're hearing some promising news on the vaccines that are being generated, but realizing it's going to take a while to get those vaccines out there and get things back to some state of normalcy as far as what we would call the pre-COVID world. Okay, Eric, that's all I have as far as the presentation.
Excellent, very good, George. Thank you. Delene Lantz, our General Counsel, is up next. George, before you go too far there, one quick question came in on the Sunshine Act. If you happen to know now, great. If not, we can get back to it later. What ADA, Americans with Disabilities Act, requirements apply to public meetings and public commenting?
None, as far as I know. The Americans with Disabilities Act essentially refers to an agency's actually lack of ability, or an agency's obligation to protect the health information of its employees.
I think let's get back to that question. I think you might be thinking of HIPAA rather than the ADA.
No, but
okay.
Go ahead with your question.
All right, I apologize. Let's just continue with the program. We will come back to that one, but let's just continue with the program.
I'll just jump in here. Some questions have come up primarily from requesters who have sought infection rates and testing rates of municipal employees. Our response has been that it's okay to release that on what I want to say, as a class, but not, you cannot release individual health information of your employees. So that if you are a municipality and you have an employee who may have been infected, you can't tell people that, but you can say, of our total workforce, we experienced an infection rate of 10%, 20%, something like that. that would be consistent with the Americans with Disabilities Act. And the only reason I'm up on this, Eric, is that I just got done doing a bunch of research for a new webinar that I'll get our points in that we're going to release in January on other confidentiality laws.
Thank you very much. I appreciate that. All right, and now we will go to Delene Lantz, our General Counsel. We'll talk about our mediation program and other issues at the OOR. Thanks, Delene.
Thanks, Eric. So good afternoon, everyone. I appreciate you joining us in this very different type of annual training that we typically present. I wanted to talk basically about office operations. We continue to operate after the Governor Wolf declared his disaster emergency. Our office, our appeals officers went 100% remote at that time. But the administrative staff, which we have 4 administrative officers actually, we had to rotate our schedules because just due to the nature of what we do in this office, we receive legal mail, we receive correspondence from requesters. Not everything is submitted electronically. So we actually had to physically come in and process mail. And also issue orders. So the administrative staff was really good about working out schedules that were safe for everyone to enter the building where we're at here. Prior to March, we had just entered our continuing operations plan. It's called COOP. So we had actually put this, had gone ahead and registered our continuing operations plan in case of a disaster just a couple months before this happened. So we did have a general idea of how things would be handled at that time. So that was very helpful in doing that for behind the scenes. Like I said, the administrative officers came in, we handled the legal mail. We also have a new database that was supposed to come out in the spring that we just had to kind of put on hold due to the pandemic, but we are just testing that now, and that actually allows all the appeals materials to be filed through a portal. So if you have computer access, once we're done with the testing phase, you will be able to file your appeal. If you're an agency, you will be given access to that portal to receive the information. You can submit information to your appeals officer through the portal. So that is really going to be very helpful in the future as we continue to work with remote, work, which I feel like we will at least through the winter until, as George said, we do get the vaccines. The mediation front, there's been an uptick in mediations during the pandemic, which I thought was very interesting. And most people were very cordial. And we actually got a lot of mediations taken care of because both parties were willing to participate in mediation. They came in good faith. So that was a pleasant surprise that I continued to mediate. And actually the format with the conference calls that we have done, and some through Skype, was actually very effective. So mediations continued, to just progress. And we actually, like I said, had an uptick in mediations. So Eric, that's all I really have. It was very brief, but I know we have a lot more interesting information from our other presenters that I want to be able to allow time for. So I'd be happy to answer any questions, through the chat or email. So thank you.
Fantastic. Thank you very much, Delene. I appreciate it. We our next on our agenda is going to be Nathan Byerly. He is the Deputy Director of the Office of Open Records, and he is going to talk about some of our advisories. We issued 2 advisories this year. We updated them regularly. One about the right to know law and COVID-19, one about the Sunshine Act and COVID-19. And Nathan, I will turn it over to you. I'm going to go ahead and share the screen on my end. I know you have some slides to present, so I'll handle that here. And the floor is yours. All right, ready when you are, Nathan. You are still on mute there, if that's...
All right, thank you. Can you hear me now?
Yes, absolutely.
All right. Thank you, everybody, for joining us. Like the other participants have said thus far, we really appreciate the opportunity we have to give you some updates on these things. I'm going to cover, as Erik said, the OOR's advisories. And before I jump into that, I just want to take a step back and cover just remembering some of the basics of the right to know law and how it works even in a pandemic. And that is to remember it's a statutory duty. And even though there may be a situation where the temptation can be to just treat this as a normal situation and push it down the line of response and priority, it is a statutory duty. And there are certain timeframes that agencies are still required to comply with and to meet. So it is a law that is built to build trust and accountability in government, and we do that through the accountability aspect. And it's especially important, as Erik has said several times throughout this pandemic, it's especially important to build that type of trust and confidence in government in a time of crisis. And the right to know law is there to help do that. At this point, if you do not have within your continuity of operations or continuity of government plans or emergency reaction policies, a portion addressing right to know, we would heavily advise that you do that just so that you have a framework and guideline on how to react to disaster declarations or situations that are similar that may arise, so you know how to navigate the right to know law and make them specific to the right to know law. One of the key components of coming up with that plan is communication, and I'll emphasize that a couple times throughout this process. And as Erik has said, in looking through the questions that were asked, as the Office of Open Records, we're looking to improve our ability in responding to the requesters and agencies as they interact with us through an appeal. But agencies, I encourage you to work with your requesters when you're trying to fulfill requests, and reach out to them, explain to them some of the logistical hurdles that you might be facing and some of the staffing issues that might be there, or access to buildings, so that the requester will be better able to understand why or why not it's working out that you're able to get records to them in a certain amount of time. And it may be different from what you've done in the past. And also to the requesters, be patient, realizing that these hurdles, even though we're months beyond the beginning of this, still do exist and still do come up from time to time. And if there's no immediate need for the record as you as a requester, consider postponing, maybe waiting till we can, agencies can get back to a little more of a normal type situation and use their assets to address the records that are of immediate need and are being requested at that time and needed to be responded to at that time. And then just a general mutual consideration, and Erik again has, and we have as the Office of Open Records emphasized this again and again, is common sense and common courtesy. And it's nice to hear, as Delene was saying, that on the mediation front, people are generally being courteous and really trying to work together through this, because using that common sense and common courtesy will obviously be able to help us better navigate this as we move forward. And getting into the OOR advisory specifically, the system that we set up paralleled the governor's disaster declaration. We used and referenced the same colored phases that were in the disaster declaration. And our purpose on that was just to minimize confusion. We tried to keep it as simplistic as we could. We tried to be out there as quickly as we could, giving people guidance and agencies guidance on how to navigate the right to know law. We were trying to avoid and cut down on any negative impact on requesters and agencies through this, because the opportunity for those negative impacts were many and they were very diverse. But the end focus and the core focus were twofold. One was to maximize due process rights for everyone. We want to give an equal and fair opportunity to the parties to participate before the Office of Open Records and explain either why they think they should be given access to the records, or for agencies why they believe that exemptions apply. And that applies to all involved, the requester, agency, and even third parties. They should have that opportunity to be able to be involved in the appeal process before the Office of Open Records. And then, of course, the other obvious one that we would want to focus on is maintaining the safety of the public and the safety of agency employees. And we address those in our advisories as well. And even in our, which I mentioned earlier, our Act 77 guidelines, the emphasis of keeping everyone safe as we work through this pandemic and the disaster declaration. So the first phase that we faced was the red phase. At that point, at the request level, we indicated that if an agency was closed on a given day, we did not look at that and would not consider that as a business day that counted toward the 5 business days that are laid out in Section 901. Another law that we referenced, and we're very emphatic on seeking advice of counsel on this one, was that agencies could invoke 35 PA 7501D and suspend the need to comply with certain laws and requirements. Again, that was a case-by-case basis, would vary from agency to agency, and we made sure to emphasize, like I said, that they contacted counsel before invoking that aspect in that law. Then at the appeal level, we initially invoked an indefinite extension on the appeals and then worked through procedural issues on a case-by-case basis. So it may have differed from agency to agency, from issue to issue. It gave us the ability to be flexible and help both the requester and the agency, like I said, get the due process rights to which they were entitled, and it has gone as well as we could have expected and been fairly smooth in working through that. In late April, we took a little bit of a step back from that and then invoked only a 30-day extension on appeals. And again, we worked through the procedural issues that each case may have in its own unique circumstance, and we did that on a case-by-case basis as well. After that, we moved to the yellow and green phase, and that was the time that agencies returned to processing right-to-know requests and working through appeals under normal circumstances. And that's where we're at now, is agencies should be processing right-to-know requests as they would under normal circumstances and working through the statutory requirements that are set forth there in the right-to-know law and the timeframes that are included therein. In July, Act 77 became law. It applies to Commonwealth agencies only. I'm not really going to go into any detail on it here for lack of time, but the Office of Open Records also developed guidelines related to Act 77, as we were required to do that under the Act. And I think that other agencies can still benefit from reviewing and applying Act 77 to their own, the Act 77 guidelines to their own individual circumstance, because it does address things like information regarding employee safety, getting access to buildings and those types of things. And I think those could be helpful to helping local agencies continue to work through this as well. In looking ahead, obviously we don't know, where this is going to go. I think some of us, and I know I am, surprised where we're at today. I thought we would have been back to work within a few weeks, but we're not. So in looking ahead to the future, I can advise you to check the OOR webpage regularly. We are monitoring the situation. We're keeping track of which counties may or may not go into another phase. If we have to go back to that, we will be on top of that and give guidance and advisories as to what the right-to-know law will direct us to do in that situation. Carefully review the package you're sent by the OOR, the appeal packet. That will, and the notice of appeal, that will show you what the time deadlines are and what you have for your target dates to get information in, and work with your solicitor or agency counsel in hitting those deadlines. Keep them updated. Even if they, that they regularly check the Office of Open Records website and they stay up to date on right-to-know matters, it's still good to remind them, hey, did you see the newest posting by the OOR? Or I noticed this got updated. Just keep them in the loop as well. And then again, to emphasize, communicate with requesters, and especially here with the OOR. If you run into a situation where the pandemic, the disaster declaration is impacting your ability to be involved in the appeal, whether you're a requester or an agency, please reach out to your appeals officer and let them know what is going on. Brief them on your logistical issues. We even have a situation now where we're facing an appeal, and one of the parties has a positive test result, and it is impacting their ability to be involved in the appeal. And the appeal, we've invoked a extension on that case. So you can continue to work through that and be able to be involved that way. And then I would just say, as was noted in the questions, that people indicated there was some difficulty at times interacting with the appeals officers. If you feel that there is a breakdown, feel free to pick up the phone and give a call and talk with one of the admins to make sure that we're getting the emails and that you're getting all the communications and emails from the Office of Open Records, and hopefully that will help avoid some of those breakdowns in communication, because like I said, that is a key element of keeping all of this working smoothly. And that's all I have, Eric, and I turn it back over to you.
All right, thank you very much, Nathan. I appreciate it. Just a note to my co-hosts out there, when Tom Howell comes on, and he's up next, I'm not entirely sure what the process is for getting him on, so please look for him in the attendee list and make sure that his video and audio, that he can turn those on. In fact, there we are, there's Tom. One of the things I like about good discussions like this is that people might not always agree on everything that gets said, and I know that we've worked hard this year to not contradict anything coming out of the governor's office. We worked very hard to, in terms of our process and our advisories, focus on the phases that the governor set. And I know that, Tom, the Commonwealth agencies have had just massive challenges this year. So thank you again for being with us today, and I look forward to hearing from you.
Great, thank you so much, Eric. We really appreciate the Office of Open Records assistance and cooperation throughout these trying times. I think, as is always the case, we may come to different conclusions on things like legislative interpretation, but we all appreciate the respectful dialogue and the end result of ensuring transparency for those in the Commonwealth and throughout the country. I do want to make one initial note. With respect to the survey, I'd just like to remind the attendees that because only one response was provided for the approximately 40 Commonwealth executive agencies, those numbers may be skewed toward locals, just because rather than 40 responses on a percentage basis, you had one that represents 40 different entries. So keep in mind, as I'm going through what executive agencies did during the pandemic and how we reacted and what our challenges were, that it may seem not necessarily consistent with the numbers in the statistics from the survey, but that's why. Really, it's a consolidated response that addressed 40 different entities. So we started out this process, as someone mentioned earlier, during the week of March 9th, thinking that anything that happened was going to be short term. I guess we were eternal optimists. We started to see COVID cases during that first and second week of March, and certain regional offices started to shut down, particularly Southeast Pennsylvania. We started to see situations where PennDOT offices, DEP offices, entities that have these various regional presences had to be closed to the public to try to stop the spread of COVID-19 when it was really still in its infancy. In those situations, the agency open records offices, which are located by and large in Dauphin County, some of course in Cumberland County for corrections and things like that, but really central Pennsylvania, those Arrow offices were receiving requests and processing requests, but they had a problem. That problem is their personnel in the regional offices were not physically there to respond to requests that had to be distributed regionally. And in many cases, those agencies in particular have records that are paper. DEP, for example, has a ton of paper records because they're dealing with things like, maps and plats and things that go back almost on a historical basis. That was a challenge. At that point in time, We attempted to work with requesters to seek extensions of time beyond the 30 days to provide those kinds of records, again, hoping that agency offices would be open and accessible in relatively short order. Of course, in the coming weeks, really starting March 16th or so, agencies in the Capitol complex and throughout the mid-state also began to close. At that point, I think people were still very hopeful that it was going to be short-term, that we would be working from home or just not coming into the office in some way, shape, or form for a few weeks, and then we'd be able to get back to normal. Again, that didn't happen. I'd say after a few days, it became clear that we were dealing with really an extraordinary situation. And we began to move toward really the first steps. I think we're working toward working remotely. Agency technologies varied. Back then in March, they actually varied quite a bit more than they do now. At the time, some agencies had ready access to electronic records. They had the capability to review and produce those records electronically. Other arrows in particular, often who serve in an administrative role, were not in possession of laptops. They weren't even in possession necessarily of cell phones. Commonwealth issued cell phones. So you're dealing with a whole lot of people who really were remoting in from their personal computers, taxing the Commonwealth's VPN system, the bandwidth of their local providers, and that's something that I think the Commonwealth was not alone in. Certainly many private businesses in the early days of the pandemic also expressed difficulties with things like bandwidth, with things like technology and resources to respond in a timely manner to the demands of the workplace and of the workforce. As that was going on, a lot of agencies were able to close out requests that had been open, really material that had been collected, that had been reviewed, that had undergone any necessary legal review. Others were simply not in a position to be able to close them out because many agencies, Department of Health, Pennsylvania Emergency Management Agency, among numerous others, were devoted essentially full-time to the pandemic response. These are agencies that often don't have a very visible presence in Commonwealth government. They're agencies that go along doing the necessary work of the Commonwealth and of their mission, but in times of crisis, they are devoted to addressing that crisis. And those agencies in particular weren't necessarily able to close out requests while their offices were closed. Many others worked to gain remote access to their resources at that point. In other words, procure the laptops, the cell phones, the technology, the VPN access for their agency open records officers, for their attorneys. And one thing that's often lost in this, resources for the records custodians, because responding to right-to-know requests is not just about the agency open records officer, and it's not just about the agency legal counsel. It's about the folks in the field who have the records. And that can be, everyone from, an administrative assistant to a department head, all of whom have very different technological resources at their disposal. During this period of time, one of the paramount objectives was protecting the health and safety of Commonwealth employees. And, as Nate mentioned earlier, not subjecting folks to risk of disease and health crises was very important, I think, to the administration. And because of that, a lot of work was dedicated to making sure that people can do what they need to do remotely. I do want to add, Nate mentioned the Title 35 provisions that allow the suspension of regulations and statutes. I am not aware of executive agencies ordinarily using that provision. In fact, the provision refers to political subdivisions and their ability to suspend laws and regulatory provisions. The provisions in Title 35 relating to executive agencies authority is somewhat different, and it allows the governor to suspend regulatory statutes. As far as I know, that was not routinely or even, frankly, even occasionally used by executive agencies. Rather, what executive agencies were struggling with was the time frame applicable to responding to right to know requests when offices were closed. You know, under the law, when offices are not open, they are, and frankly, under agency policies that were developed in accordance with the right to know law, when agencies are closed pursuant to the applicable management directives, those aren't business days. And most agencies used that time to devote themselves to the pandemic until things can get really marching forward from the right to know perspective. As we became aware, or it became more clear that this really was the new normal and we were looking at a long-term process here, most agencies were able to get on somewhat of a more regular operating schedule. As such, by May 29th, all executive agencies were responding to right to know requests in the ordinary course. Notwithstanding that, challenges persist. Agencies that were at the forefront of the pandemic response had to bring in staff from other agencies to assist in processing right to know requests. Again, agencies like health, like DCED, like PEMA, relied on a lot of assistance from other agencies that weren't as directly involved in the initial pandemic response. Ironically, I think many of those agencies became involved in the subsequent pandemic response as we started to get into phase reopening and things like that. So there was a need to move with quite a bit of alacrity to try to reposition people, at least virtually, and provide them quick training to get up to speed on their sister agencies' operations and obligations to make sure that we can really get through the requests that we're mounting. During this time, most agencies that were involved in the pandemic, ironically enough, received a tremendous influx of right to know requests. In essence, the agencies that were most burdened by COVID itself were also tasked with responding to the most numerous right to know requests. Because of this, there were a number of instances where agencies reached out to requesters for additional time. And most often, I have to say, requesters were understanding and helpful, and agencies did the best that they could to roll out information as it became available, rather than holding everything until the last day and then producing it in bulk. I think everyone really tried to do what they could to push material out as it became available, but really, under the circumstances, it was very difficult to get it all out within the 30-day extension. Again, as I said, though, I think most requesters were very understanding and cooperative, and we're certainly appreciative of their understanding and their efforts. It's important to remember, a lot of the stuff that is involved in supporting efforts to combat the pandemic were turned around incredibly quickly. Bureaucracy is not known for moving swiftly, but it really is amazing. For example, the business exemption process, I think we all heard about, that's something that didn't exist before mid-March. It was not really even a twinkle in anyone's eye, yet by early April, they had gone through 50,000 requests, processed them all electronically and remotely, sent out responses to all of them, and by the middle of April, had published the results of those exemption requests on DCE's website, and not just published it as a list or a data dump, but actually had a very nice explainer on a county by county level, providing all kinds of information about the businesses that were permitted to remain open, what category they were in, and whether they were simply someone who was not required to seek an exemption or was a business that was entitled to an exemption. So I think really I'm proud to have worked with a lot of these folks on pulling this together, because I've never seen even private business move that swiftly, let alone government, who I think often gets a bad rap for being sort of slow to move or slow to respond. I think the agencies involved have been doing a tremendous job under incredible circumstances. And that goes for the OOR as well. I know they were early to go remote, and their communication with us has been regular and cooperative, respectful, and I really appreciate that, because certainly they're dealing with challenges as well, being really not able to come in the office, not able to convene, not able to discuss processes and developments and things like that. I do want to highlight or do a little bit of an advertisement here for what is available on a public records side of things from the administration's perspective. The Office of the Governor and the executive agencies throughout the pandemic have been publishing information about COVID, about agency operations, everything from PennDOT and driver's license center schedules, exemptions that permit things like commercial operators to continue to operate while their license may have otherwise expired, and updates about what road projects can continue, to the Department of Health, which is really at the forefront. I'm not sure if everyone's aware, but Health has, since the beginning, published daily regional case count information on its website. And as the pandemic has continued, they developed really robust data and published it to multiple websites. The COVID dashboard, the Pennsylvania Department of Health data dashboard, which is actually separate from the COVID or early warning dashboard, and the Pennsylvania Open Data Portal, which is really de-identified, unfiltered, importable data that's available to researchers. So in addition to the explainers and the presented data that's available on the Department of Health site that will provide county by county case increases, hospital utilization, things like that, they've pushed all of the raw data itself out to open data, where researchers can simply go in, access that data, and analyze it in their own software using their own models. We've published the data that's provided by third-party partners like Carnegie Mellon University, data that's provided by some of our other health partners, I think CHOP and University of Pennsylvania. All of that's available on Health's website or through Health's website. As well as the sort of customer service information about how to protect yourself from COVID, where testing is available, where cases may be in your zip code, and all of that, I think, really is hopefully putting agencies in a position where people won't even have to ask for information via right to know request. It's simply going to be out there, simply going to be available. And again, I'm proud of the work that that folks have done. I'm proud to be part of a process that has ramped that kind of stuff up really so quickly under difficult circumstances. So Erik, thank you. I appreciate you giving us some time to speak here and allow the Commonwealth agency perspective. And thanks to your office for all of your hard work during these times.
Thank you very much, Tom. I appreciate that. And thanks again for participating. I think there's no question that in 2020, a lot of unprecedented issues were faced by just about every agency in the state. And I agree with your analysis that The overwhelming majority of agencies and requesters handled it remarkably well, and agencies, Commonwealth agencies, as you laid out, and local agencies, I think in particular with the local agencies in regards to the Sunshine Act and making public meetings available online, really turned on a dime as well, and did that kind of quick adaptation that you were saying that government agencies often are not known for, a reputation that may or may not be earned in some cases, but it was a remarkable year, and a lot of people did a lot of remarkable work. So thank you. Our next speaker is Melewsky with the Pennsylvania NewsMedia Association. Melissa, pardon me, will give some requester perspective, particularly from the news media perspective, about the Right to Know law and the Sunshine Act, and what you've seen on your end of things this year. So I will turn it over to you, Melissa. Thanks. And one of my co-hosts may need to unmute Melissa based on the way we have the settings here.
I think it's working now. Can you hear me?
Absolutely.
Thanks. So hi, everybody. It's nice to be here today. I'm in-house counsel with the Pennsylvania News Media Association. And in that role, I talk to journalists and editors and publishers on a daily basis about what they're seeing on the ground as far as access issues go. And on a typical year, I get about 1,000 access-related inquiries. We're a little bit above schedule this year, which is not surprising considering the environment we're in. I think from the beginning of the pandemic and the disaster declaration back in March, things have calmed down a little bit, but I do want to talk about some of the most common issues that I'm hearing from across the state. And these issues range from the largest agencies in the state to the tiniest ones. And I hear from, I don't hear a lot of the good things, but I do hear some of the bad. So I'm going to focus on the problems that we've seen and not necessarily the successes, because I'm not the best source for that information. But I do believe on average, I'm hearing less or fewer problems today than I was 6 months ago, which is good. We're moving in the right direction. So I'll start by talking about the Sunshine Act and some of the most common issues I'm hearing from journalists and members of the public and even some elected officials. The most frequently asked question is, does the Sunshine Act still apply? There was a lot of confusion because agencies started just canceling meetings in order to comply with social distancing and health requirements. Yes, the Sunshine Act still applies. George talked about that a little bit earlier today. We're in perfect agreement on that. The Sunshine Act remains in effect. The next most common question has to do with Act 15, which was passed, I believe, in April. It was enacted, signed in April, which allows remote public meetings to participate. And a lot of the issues that have cropped up because of Act 15 and its implementation and how agencies are using technology or not using technology to facilitate public access. So when I hear about issues with agencies, most commonly is that they're either not providing enough information to allow the public to participate, or if they are providing that information, the technology that they're relying on isn't functioning the way the agency believes it is. And I participated in several public meetings myself as just a member of the public. And I think the agencies are doing their best, but it doesn't always work out so great. The most common issue is you either lose the feed, or if they're doing streaming like we're doing now, the feed cuts out. The agency loses the ability to accept public comment during the meeting. The second most common issue is spacing limitations. Sometimes an agency will use a method of public access that is limited to 50 people or 100 people or whatever the number is, and it's not enough. And when that happens, I mean, I think the same logic applies to virtual meetings as it does to in-person meetings. If your in-person physical meeting can't accommodate everyone interested in attending, you have to find a bigger room. The same logic applies to a virtual meeting. If your virtual meeting room doesn't accommodate everyone who's interested in attending, you need to find a bigger virtual room. And that may mean a subscription cost to a larger platform. It may you have to work with your IT folks to get everyone interested in attending the ability to participate fully in a meeting. Sometimes agencies, and I hear this frequently with the smaller agencies, usually townships, some of them are just plain old not comfortable using technology, whether it's a conference call or online technology. They're just not comfortable with it, and they continue to have public meetings and in person, which is fine, provided they're following, the recommended guidance from health authorities throughout the state. The problem that I hear about is that they have the public meeting and they only allow a small handful of people to attend. And sometimes that's one of our journalists as a representative of the public, which is great. But sometimes that means that the general public who would like to otherwise attend have been excluded. And that's obviously not acceptable under the Sunshine Act or under Act 15. So that obviously it's going to create potential liability under the Sunshine Act. But I think just as importantly, it's discouraging public access and transparency. And that's obviously no one's goal here. So in the event that an agency is not comfortable using technology and they choose to hold public meetings, it oftentimes means they're going to have to find a larger venue to accommodate everyone in as safe a method as they can. One of the other issues that I've heard about as well is the fact that there are a decent number of Pennsylvanians who cannot use digital technology. It's a common misunderstanding that we live in a completely connected society. We in fact do not. There are significant numbers of Pennsylvanians who will be automatically excluded when agencies use digital only technologies for public meetings. So that's something that agencies need to be aware of as well as they move forward with Act 15 and virtual meetings. If in the event that they are having a virtual meeting using streaming technology on the internet, that is the most problematic for many Pennsylvanians because we have significant problems with access to broadband and internet technology. In those cases, I have seen agencies make an alternate means available to the same meeting via a call-in line. Or again, some agencies are saying we're going to have an X number of seats available at the public meeting. If you can't avail yourself of the virtual meeting, you can come and attend with us in person. It's really all about flexibility, and that's what I talk about with the journalists as well. I don't know how many times we can say unprecedented, but we're in unprecedented times, and it demands flexibility on the part of everyone. So I think responses from agencies from a Sunshine Act perspective have been generally very positive. I think when I've talked to local elected officials, they've been pleasantly surprised that making access easier helps them, facilitates public access, makes it better for them from a governing perspective because they have more public involvement. So that's, if we're looking for silver linings, I think that's one of them. The fact that more people have participated and shown an interest in local and state government is a positive thing because government functions best when they're actively assisted by an informed and involved citizenry. So I think that's the silver lining to come out of many of this. Issues still persist. I got a call this morning about tech limitations. What happens when an agency uses a piece of technology to facilitate public access and it cuts out halfway through the meeting. In that situation, I think the best thing to do is to have the agency first. If you're a member of the public in that situation, you've got to try to let the agency know. I mean, oftentimes the elected officials don't realize what's happening on their stream. And if they don't have someone monitoring the technology, they may not be aware. If they do become aware of the problem, the appropriate thing to do is recess the meeting and reconvene it at a later time when they're positive the technology is actually working. That's one of the more common problems is they're relying on technology and it's really just not working the way they intended it to or the way that it's supposed to. I expect that to continue. But again, I think once the agencies have learned that there's a problem, they have been responsive to, the citizens who said, look, we're trying to get access and we just can't do it. The agencies have been largely responsive and apologetic in many cases, say there's no intent to do something wrong here. It's just, it didn't function the way we thought it would for reasons that, sometimes they can figure out and sometimes they just can't. So I think on the whole, it's been there have been some snafus, but I think we're working our way through them from a Sunshine Act perspective. But I do like to tell agencies and journalists that yes, the Sunshine Act still applies. It remains in full force and effect. There is potential liability for failing to follow it. I have not advised anyone to pursue Sunshine Act litigation because of a technology failure or another problem that's foreseeable under the circumstances. I just don't think that's the right step to take in this environment. I have not seen any examples of any agencies doing anything intentionally to prohibit public access or discourage public access to public meetings. So that's very good. So that's what's going on from a Sunshine Act perspective. I do want to touch a little bit on the right to know law as well, because as the other presenters have talked about here today, it was a bit of a rough start. Back in March, when agencies were just closed, the most common issue I heard was, what happened to the right to know law? I thought they had to answer me within 5 business days. And my answer was, well, yes, they do. And the right to know law remains in full force and effect. But if their office is legitimately closed, you have to talk about computation of time and when that time starts, when the agencies are open. From our perspective, an agency is open even if they're working remotely. Working remotely is different than being closed. There are probably agencies that differ with me on that, but again, if an agency is working on other things an agency has to do, the right to know law is a statute they have to comply with as well. I do always recommend to journalists that they be as flexible as they can and reasonable as they can, because again, if a record is only in paper form and it's at the office and the agency is working remotely, there's not a lot of good options there. So to the extent agencies can facilitate access as quickly as possible, that's great. It's not always going to happen. We recognize that as members of the public and as journalists. So that was the first most common question. What happened to the right to know law? Does it still apply? The answer is yes. Nothing happened to it. It's still there. Agencies still have to comply, but I am advising journalists and members of the public to be as reasonable as possible with compliance. And I'm also recommending that they avoid the right to know law completely. If you can get access to the information you want outside the context of the right to know law, great. There's no rule that says the right to know law is the only way to get access to public information. And I think, when Thomas was talking about what the governor's office and Department of Health are doing, those are great. When an agency presents public information and makes it affirmatively available without the public having to jump through all of the right to know law hoops, it saves public resources, it saves time, it's good all around. That brings me to a question that's come up more recently. I'd say within the past month, I think agencies are trying to do just that, trying to present information and public records and access to that on their website via enhanced electronic access, which can be wonderful. The problem that I'm hearing about is that agencies have begun to charge for that without going through the approval and review process that's required under 1307 of the Right to Know law. As you all know, agencies are allowed to provide enhanced electronic access to public information. That typically comes in the form of a website. If they do choose to do that, great. If they choose to do it and charge fees, Section 1307E requires those fees to be reasonable, not for profit for the agency, and they have to be approved by the Office of Open Records. So I've encountered at least a handful of agencies in the past month or so who have gone to contractors or third parties to provide that kind of enhanced electronic access, and the third parties are charging fees that have not been approved by the Office of Open Records. So if you're an agency member and you're considering doing enhanced electronic access, I say great, full speed ahead. The more information you can put online, the better, because it will reduce the work associated with right to know law compliance. But if you do choose or work with a contractor or choose to charge fees on your own, you must go through the 1307E approval process before you do that. So that's one of the things that's coming up frequently just within the past month. I've gotten a lot of questions about what the OOR is doing, and we heard Delene talk about that. Is the Office of Open Records working? Are they working remotely? What does that mean for delays in appeal and, final determinations and appeals resolution and mediation? And in my experience, I've heard mostly positive. I mean, I think even before COVID started, the Office of Open Records routinely requested an additional 30 calendar days to deal with most appeals. And my standard advice is, if you have the time to give them that extra time on your case, you should. Sometimes that's not always possible, especially with a journalist on a deadline. But in most cases, requesters get it. They understand the Office of Open Records and agencies themselves need additional time. It's our advice to them to be as flexible as you can, as often as you can. Another question I got a lot in the past 8 months is, what are the biggest barriers to access? The most common that I've dealt with in the past few months and during the pandemic have been the DPCL, the Disease Prevention and Control Law, and HIPAA, because a lot of our journalists want to figure out what's happening at different levels of society and where the infection rates go, who is not particular people infected, but infection rates. And the DPCL, the Disease Prevention and Control Law, can be a significant barrier to access. It allows the Department of Health and other local health authorities to prohibit access to certain disease-related information. And it is the most commonly cited basis for denial in my experience when journalists or members of the public are looking for information related to the COVID infection rates, COVID infection plans for emergencies. What are nursing homes doing? What are the schools plans? The DPCL is commonly cited as a basis for denial. HIPAA is also another big barrier to access with regard to infection rates and things like that. Anytime you want to, what the Department of Health makes available is wonderful. It doesn't always answer all of our questions though. So when a journalist finds themselves looking for additional information from related to infection rates or disease protocols, things like that, they often have to file a right to know law request with the Department of Health or with the county health authority. And it's pretty standard to see the DPCL and HIPAA cited in addition to the right to know law exemptions that apply to health information as the basis for denial. And I think there are several of those that are kind of working their way up through the Office of Open Records and the courts to see where we come out on access. And I think Charles Brown was going to talk a little bit about the case law that's developed during the pandemic. So he'll probably likely hit on those or a few of those as we proceed here for more information on that. The other one was Act 77, and Nathan touched on that earlier. I get a lot of questions about Act 77 and what it means as far as compliance. I think there's a bit of a misunderstanding, at least at the public level, about what Act 77 does and most importantly, who it applies to and who it does not. I get a lot of questions about Act 77 and whether it applies to local agencies like townships or school boards or boroughs. It does not. It applies to only Commonwealth agencies that are under the governor's jurisdiction. And that's more narrow than Commonwealth agency under the right to know law itself. So Act 77 would not reach an agency, a Commonwealth agency like PIAA, for example. It would reach the Department of Health. So there's a lot of confusion about that one still. And I routinely send folks to the agencies, to the Office of Open Records guidance on Act 77. I can't tell you how many times I've cut and pasted a link to the Act 77 guidance that the OOR issued back in July. It's pretty standard for me to do that a few times a week. I think there's still a lot of confusion about what Act 77 does, what it doesn't do, what it requires. And there's a case, I think, at the Commonwealth Court just recently filed that will tell us a little bit more about the interaction between the right to know law and Act 77. And I think Charles will probably talk about that as well. I think that's it for what's happening on the ground level. I'm happy to take any questions now or later if you have them. I haven't really been checking the chat. But if you have any, I'm happy to answer them.
Very good. I think what I'm going to do, Melissa, is try and keep all the questions to one section at the end, and maybe we'll get all the presenters back on at the same time. And without speaking over each other, we'll be able to target the answers to the people who are in the best position to do that. So thank you very much. I appreciate that. And you're absolutely right. There are a ton of unknowns that we've been facing this year. We've had to deal with a pandemic, right to know law, which I can say firsthand. When the right to know law was being written, we never said, how will this apply during a global pandemic? I don't think that the Sunshine Act was necessarily written with those kinds of things in mind either. And so these laws are having to be applied to situations which were not necessarily considered when they were written. I also meant to note earlier that the appeals officers at the Office of Open Records, we have about a dozen attorneys who are our appeals officers, have just, in my view, done an amazing job this year. At one point, their caseload was on average 60 cases per appeals officer. The normal pending caseload is between 25 and 30 cases. So there was a significant influx of work over the course of the summer through the pandemic, and they've just done a tremendous job of that. So I want to thank them for that. And with that, Scott Coburn, I had a flashback earlier to a different Scott who did some work in and around the General Assembly. But Scott Coburn is here. He is with the Pennsylvania State Association of Township Supervisors, and I appreciate you being with us very much, Scott. And I think maybe one of my co-hosts needs to unmute Scott for us. Thanks.
Hey, thanks, Eric. And no problem with that. Scott Chadwick was an excellent state legislator, and it was probably actually a good thing because you might have had a bunch of participants fall off of this call very early on had they known it was going to be me. But I want to thank you. I want to thank the Office of Open Records for having this and for including PSATs, and also a special thanks to all of our members who are both participating today, and for all of the work that they have been doing to navigate the Sunshine Act and right to know law challenges the last several months. I know that you have a bunch of questions coming in on the chat and that you want to get to those. So I will be brief and just touch on a few points that have been raised by earlier speakers. And Melissa mentioned a few minutes ago the challenges that some agencies are having with broadband capabilities or just technological challenges to begin with. One of the things that we're trying to sort through with our members who are dealing with that is to provide as many options for public participation as possible. So if a township is conducting in-person meetings and has space limitations for the public, if they are uncomfortable offering it by Zoom, then in addition to having a call-in number option, also allow for people to either drop off comments or email comments in before the meetings. Melissa also mentioned having the media there. That's another suggestion that we have been making to our members to reach out to their local media representatives and extend an invitation to them if the board and staff are meeting in person, so that there is a representative of the public there. A couple of other recommendations that we have been making throughout this process, and I know George Spiess alluded to this before with agendas and minutes. While there is no requirement for having public meeting agendas, at least at this point, we've been encouraging our members to do so, and I think a lot of agencies are in fact doing that. Also, while draft minutes are not technically public records until the next public meeting, where we are seeing a lot of our membership get drafts of the minutes up on their websites or available at their buildings in pretty short order. Again, anything that they can do to ensure that that the public has as much information as possible about the meetings is a good thing. We are also, especially in the context of hybrid meetings, I know both George and Melissa referenced the challenge of what do we do if there's not enough room for everybody. One of the things that we have talked to our folks about is making sure everybody understands that from the get-go in the advertisement for the meeting. So if the township wants to accommodate as many people as it can within that public meeting space, recognizing that they may not have enough room, they should be making that clear. We can only take the first 20 people in here. And oh, by the way, there are the following other remote participation options available, so that you're not getting into one of the situations where there just isn't room and there's not another space that people can be moving to in a rapid manner. I think that's really it from a Sunshine perspective. I would say that this is anecdotal, but I think the majority of our membership is back to having their meetings in person with a pretty decent combination of pure virtual meetings and hybrid meetings. On the subject of the right to know law, just a couple of quick points. Melissa touched on it a couple minutes ago about, what do we do if agencies are, working from home? Some of our members are on a staggered schedule, Monday, Wednesday, Friday in the office, Tuesday, Thursday at home. Recommendation that we have made from the get-go is that if folks are working from home, whether it's the open records officer or somebody who has records that are subject to a request, for the open records officer to reach out as soon as possible to the requester and see if those, see if they can work out a timetable that accommodates the challenges of maybe not being able to get into the office for a couple of days, while at the same time getting the information to the requesters. I think the information that we have is pretty consistent with the survey results that Eric talked about at the beginning. Very good portion of our membership has not seen a change to their typical right to know requests over the past several months. Many of them are continuing to get lots, some of them only in drips and drabs. They are continuing to see what I call some of the statewide or regional blanket requests that get sent out electronically to huge swaths of local agencies at one time. So they continue to address those. We have heard from some of the membership that it has seen an increase in the number of requests, that those are being driven in large part to the fact that more people are working from home and are paying more attention to things in their neighborhood and communities. Again, this is all anecdotal, but many more requests of a neighbor to neighbor variety. Hey, is my neighbor does my neighbor have a permit for the work that is being conducted next door? Was that pool put in appropriately? Just things that as people are around more, they see more and then raise it. But by and large, operations of the right to know law have continued as normal, subject to some of the limited challenges that we talked about. So I think that's pretty much it from my standpoint. As Melissa said, happy to stick around as long as necessary to answer everybody's questions. And again, Eric, thanks to you and the Office of Open Records for having me.
Yeah, absolutely, Scott. Thank you. I appreciate that very much. And Q&A is just around the corner. Up next is Charles Brown. Charles is our Chief Counsel at the Office of Open Records. He is one of the very few people in the office today, and Charles is going to talk about case law during this very interesting year. So take it away, Charles.
Okay, so can everybody hear me?
Yes, sir.
Okay, yeah. Thanks, Eric, and I want to thank all the attendees for attending this presentation, as well as the presenters for really making this probably one of the better annual trainings that we've had. My contribution to the cause is I'm going to go briefly over some important cases that I think came out of the excuse me, the Supreme Court and the Commonwealth Court since the last training we had. And the first one I want to talk about is the Easton Area School District versus Miller case. Now, this case involved a request for a school bus video, which apparently showed a teacher roughing up a student. And the school district denied access to the record. They argued it was an education record, which would be confidential under the Federal Educational Rights Privacy Act. when it came to the OOR, we concluded that it had nothing to do with students' education, and therefore FERPA, the federal law, didn't apply. The school district took it up to Common Pleas Court. The court agreed with us. The school district then took it up to the Commonwealth Court, and the Commonwealth Court said it wasn't a education record because it was more focused on the actions of the teacher as opposed to the student. Now, when it got appealed up to the Supreme Court also found that it wasn't a record of an education record, but they also dug a little deeper into FERPA, and they found that personally identifiable information regarding a student is subject to withholding. So they ordered disclosure, but ordered that the images of the student be de-identified. The next case we saw coming out of the Supreme Court was the ACLU versus the Pennsylvania State Police. And here the request sought the state police's policy on using social media to monitor for potential crime. State police said, no, you can't have that. Disclosure would threaten law enforcement activities, threaten public safeties. And when it came to us, we ordered an in-camera review and actually looked at the record and found that it was just generally innocuous information regarding citing onto the internet. And the state police had also submitted an affidavit of their director of Bureau of Criminal Investigations, who felt that disclosure would threaten public safety. But when we looked at it, we said this is just innocuous information. So when it went up to the Commonwealth Court pretty much just relied on the affidavit of the state trooper, and there was a request from the requester to look at the records we looked at. The court decided not to do that, and they overturned us. And the requester eventually went up to the Supreme Court, and the Supreme Court said that it was really appropriate for the lower court to review all the evidence that was presented before the OOR, and they concluded that they reviewed the record and found that it was just innocuous information. So they ordered disclosure. And I think really what the court very strongly hinted at was that the Commonwealth Court should have looked at the in-camera records themselves as well. The next case involves the city of Harrisburg versus Jonathan Prince, and this was a request for spreadsheets of donors who contributed to the city of Harrisburg's anti-gun ordinance, and the city denied it under the donor exemption. We went back and forth with the city trying to find out who are individual donors and who are corporate donors, and that's because the donor exemption applies only to individuals. And the city refused to answer our questions, so we had no choice but to grant access. The Common Police Court here in Dauphin County decided to take new evidence, and that's something that you see a fairly frequent amount at Common Pleas level, but very rarely at the Commonwealth Court level. So they took additional evidence and reversed finding that this information was donor information. When it went up to the Commonwealth Court had to decide whether or not this was a financial record, and they concluded that it was not a financial record and therefore could be redacted. And when it went up to the Supreme Court, the Supreme Court said that the spreadsheet showed the receipt of agency funds for the purposes of furthering this, this ordinance. But what they also did was they remanded it back to the trial court for the purpose of performing the balancing test under the constitutional right to privacy. That is, whether a right to privacy or a public interest in disclosure outweighs an individual's right to privacy. So those were three cases coming out of the Supreme Court. In Payne versus Department of Health, the Commonwealth Court again reinforced the notion that affidavits need to be detailed, non-conclusory, and made in good faith. And here, requests sought scores for medical marijuana license applicants, and Department of Health denied under the internal pre-decisional deliberations exemption, and we agreed with them. But the court looked at the evidence, and the court felt that the evidence was, insufficient. So, again, you do need to make your affidavits very detailed and non-conclusory. And one of the interesting things about this case was the court noted that the department had released similar records in the past, which seemed to undercut their claim of confidentiality. And that's actually the first time that I've seen the Commonwealth Court sort of, make notice of that. In Smart Communications versus Wisniewski, the inmate sought a statement of work which was withheld from a contract to provide inmate email services, and the Department of Corrections claimed that the trade secrets exemption, that this information were trade secrets. The Commonwealth Court, disagreed. They held that this was part of a contract, and a contract is a financial record to which the trade secret exemption can't be applied. And the right to know law specifically states that only certain exemptions can be applied to financial records. And the interesting thing about this is, I think you should compare it with the Global Telelink case, where a requester sought records from another contract, and I believe these were financial records of the contractor, and we held they were part of the contract, and therefore they were subject to disclosure and couldn't be withheld as trade secrets. In Global Telelink, the court said, no, this has nothing to do with the contract, even though it was attached to the contract. So I think those are, if you're looking at trying to get records from contracts, those are a couple of cases to keep in mind. In Labor and Industry versus Darlington, I think the court put a further fine point on what constitutes an investigation for purposes of the non-criminal investigation exemption. Here, a requester sought boiler inspection reports, and during the course of the appeal, the OOR found that there were two types of records. One were yearly annual inspections for all boilers that have to be done, and then the others were inspections done as a result of an incident. And they concluded that those two were different types of investigations, and found that the inspections didn't fall within the exemption. And the Commonwealth Court agreed, and they looked to the boiler law and found that that the statute has two different definitions. One is for inspections, which are to be done on an annual basis and have no connection to any sort of accident, and the others are investigations, which are done when an accident occurs. So I think that's another fine point on the B-17 exemption. In Pennsylvania Turnpike versus Electronic Transcription Corporation, the court really took us to task for not providing adequate due process to a bidder whose records were requested. When the Turnpike received the request and received the appeal, they never notified the requester until we had said, did you notify? They never notified the bidder until we said, did you notify the bidder? And so they finally notified the bidder, and the bidder asked to participate. And we said, well, we need more time from the requester, and the requester was unwilling to give us that time. So we said, well, we can't, you didn't meet your burden of proof because you didn't submit sufficient evidence. The bidder filed for reconsideration, which, under traditional rules of reconsideration, we can't take new evidence on. But I think what the court was really doing was saying to us, in instances involving due process, reopen the record and let the party have their day in court. And then just a couple of minor cases, PUC versus Friedman. requesters sought records related to blast radiuses around gas pipelines. And there's an act called the Confidential Security Information Act, which allows PUC to designate, or the gas companies, utility companies, to designate information as security related. We held it wasn't security related, and but it was exempt under the infrastructure security exemption. When it went up to the Commonwealth Court, the Commonwealth Court said, OOR, you have no jurisdiction to even consider whether something's confidential security information. That is reserved solely to the PUC and then to the court on further appeal. And then finally, we had a case of the Liquor Control Board versus Representative Burns, who was seeking records of the number of liquor licenses available for auction for restaurants. And the LCB claimed the trade secret exemption, and the court, in some pretty interesting language, seemed to indicate that they don't like government agencies invoking the trade secret exemption, that that exemption is more appropriate for businesses conducting business in the economy, not a regulatory entity. So with that, I think we have a couple minutes left, and I'll turn it back over to you.
All right, thank you very much, Charles. In the chat while you were talking, a couple requests came up to make the citations of the cases that you were discussing available. So if you wouldn't mind just putting that together and sending it to me, I'm going to post those on the OOR blog later this week. I know many, perhaps all of those cases are in the Right to Know Law case law index that we maintain on our website, but having the ones you just discussed available easily would, I think, also be a very good idea. All right, we do only have a couple minutes left. I am going to go a little past 3:30 here with these questions. If my fellow presenters don't mind turning on your cameras and joining us again, and my co-hosts, please be aware that we might need to unmute folks. This is our first time hosting a large-scale Zoom meeting like this. You may have noticed a hiccup or two along the way, hopefully not too many. But if my co-host can be ready to do that, that would be fantastic. Since we have so many outstanding folks here from outside of the OOR, which we don't usually have at our annual training, I'm going to try to direct as many questions to them as possible. Every year, it seems like there's a theme that develops in the questions we get at our annual training. This year's theme, as best I can tell, seems to be OOR process. So some of the questions won't be appropriate for the other folks necessarily, but I'm going to hit the ones that clearly are first. Scott and Melissa, I think anybody feel free to answer, but Scott and Melissa, I think this might be in your wheelhouse. Are attendees at public meetings required to give their names for Zoom meetings if they do not make comments during the public comment period?
Here's what I would say is that under the Sunshine Act, and in Act 15, or let me step back. Act 15 did not change any of those types of requirements under the Sunshine Act. So if you've got to sign in to make public comment, whether it's in person or virtual, it doesn't matter. Melissa, I don't know if you have any other thoughts on that.
Yeah, I mean, I think agencies can require you to give your name and even where you pay taxes if you're going to provide public comment, because agencies can limit public comment to residents and taxpayers. So they would necessarily need your information to implement that kind of limitation. But if you're just listening in and not providing public comment, then I don't see a justification for a name requirement.
Excellent. Scott and Tom, probably best for you on this one. If an agency finds itself without an open records officer, or even without any support staff, if it's a small agency, due to COVID, what should that agency do to ensure that it is complying with the right to know law?
I think that they need to go and take some pretty immediate action to find somebody else. I mean, we recommend, and I know the Office of Open Records does, recommends having alternate OROs. In that case, you need to find somebody who is going to be capable and able to fulfill the request. At the same time, I think, coming back to some of the concepts of flexibility that we've talked about for the last couple of hours, they should make an immediate outreach to the requester, explain the situation, they're working through it, and then try to get that accommodated that way.
Yeah, Tom, do you have anything to add to that, or could you unmute Tom, please? There you go.
Thank you very much. Yeah, I mean, I think the key is going to be whether your agency is actually operating. What is your agency engaged in? What are they doing? Is there someone, is the office frankly working, or are you truly shut down? It's become a difficult line to draw in this era of electronic access and the 24/7 workplace. Saturdays and Sundays are still not business days, and I don't think anybody would argue that agencies are open on Saturdays and Sundays, but many of us are working on Saturdays and Sundays. So I think, I know Melissa had a point earlier, if people are working, she would consider the agency to be open, but I think that needs to be tempered with an understanding that very often people are working around the clock, and an agency in that situation really ought to contemplate what their operations are before determining how to proceed. And if the municipality is out doing road work and issuing building permits, then yeah, pretty clearly they're going to want to be responding to right to know requests from my perspective.
Does anybody want to add to that? Excellent, very good, thank you. Melissa, Tom, and Scott, this is a little bit lengthy, but I think it's a good question that we run into pretty regularly. Section 3101.1 of the Right to Know law states that its provisions do not apply regarding access to records if they conflict with other federal or state law. There is not much court or OOR precedent on this, but what precedent there is seems to limit the preemption to procedural aspects as opposed to substantive aspects. My specific questions. Does an agency that has a separate statute about record access still have to follow the right to know law deadlines and formalities if the requester invokes the right to know law in his response? And where do an agency's right to know law obligations begin and end when there is a separate statute addressing how and when records can be requested?
Gentlemen, you want me to go? I'll give the requester's perspective first. So when I hear this question from members of the public, because they've encountered it from an agency, what I tell them is the right to know law governs and fills in the blanks for any law that doesn't specifically address an issue. So what typically happens is there's a statute that says a tiny little piece about access. This record is or is not public, and it's otherwise silent as to process, timing, mechanisms, everything like that, appeals. So I'm not aware of any other comprehensive statute that talks about accessing records. I think most often you find yourself in a situation where there's one little piece of information or several pieces of information that are either made public or non-public, and that little piece is plugged into the right to know law framework, for lack of a better description. Gentlemen?
Yeah, so I think there are certain areas in which the General Assembly or the federal government have completely usurped right to know law processes. Driver's licenses come to mind. Driver's records has an entirely different process that's really a consortium of both federal and state law addressing access to those types of records. In addition, you have some oddball laws like the Personnel File Inspection Act. That is a completely separate process from right to know, and it's almost as though never the two shall meet. Somebody can certainly make a right to know request for personnel records that's probably going to be denied given the exceptions in the right to know law. But if they're that individual employee, they may very well have a right to pursue access to that under the Personnel Records and File Inspection Act. So I guess the answer is it depends, and it's a rare occasion.
Very good. Scott, that cover your thoughts too?
Absolutely.
Perfect. Melissa, and I know that I believe it's Representative Topper in the House has some legislation pending on this, so you feel free to discuss that here too. What redress does a requester have when a local agency does not comply with an OOR final determination and the requester has exhausted every avenue from the local courts and the local courts will not enforce an OOR FD? Considering the Supreme Court still has not ruled on Uniontown versus Department of Corrections, how will the OOR rewrite or add law to the right to know law for better enforcement? And I will add there that in addition to the Representative Topper's bill, Senator Blake has legislation in Senate Bill 783, which includes a provision that essentially says that if an agency does not comply with a final order under the right to know law, that they are subject to a daily financial sanction. I should have mentioned that one as well. Melissa.
Yeah, I mean, I think it's rare, thankfully rare to have an agency ignore an order from the Office of Open Records. It's even more rare to have one ignore a court order. I mean, that's sanctionable under the right to know law, and I think under the rules of court. So that's, I think, thankfully very rare. But I do believe that the enforcement mechanisms need to be beefed up a little bit under the right to know law, because it's not unusual for you to, as a requester, to get a good decision from the Office of Open Records and then hear nothing else from the agency. It's basically kind of an invitation to just, say, hey, sue me, because I think requesters are at a disadvantage in that aspect because they have to hire a lawyer, pay the associated fees, and that's all coming out of their own pocket. There are no government-funded lawyers to seek enforcement of a right to know law final determination from the Office of Open Records or other appeals officers. So I think there does need to be stronger mechanisms for enforcement, stronger penalties for failure to enforce. And I think we're working with legislators on making that happen as part of a number of different bills, some more comprehensive than others.
Very good. Anybody else? All right. Tom and Scott, sort of on the other end of that equation, when a requester uses the right to know law to harass members of an agency, and we hear this question periodically from agencies across the state, when a requester is using the right to know law as a way to harass members of an agency, what redress does the agency have?
Well, I know that there is legislation that has been discussed in the General Assembly that would address what is called in the legislation, I think the term was disruptive requests. So we'll see where that goes. Beyond that, there's not a whole lot. I will say that I am familiar with one township in Dauphin County that actually sued a requester in the Court of Common Pleas because of just this situation. Dozens and dozens of requests over a couple of month period that ultimately got resolved. Fortunately, it doesn't happen all that often. I guess that's probably all I could say at this point.
Yeah, I think unfortunately, it does happen, but ultimately, if the requests are valid requests for information, unless they are repeated requests for the same record, the right to know law doesn't provide any reason to deny those otherwise lawful requests. If you're talking about really extraordinary cases where someone's actually making a threat or has, I think the terminology from the criminal law is, no legitimate purpose. There may be other avenues available, an abusive process and stuff like that. But I find that to rarely be the case, because even the most prolific and often ungrounded requesters usually have some grain of a legitimate purpose in asking for the records they're asking for.
That was the claim in the Dauphin County Township situation. That was the claim that the township raised, was abuse of process.
And I'll add another reference to Representative Topper's bill. In addition to having some provisions relating to requesters being able to recoup attorney fees, it also has provisions relating to vexatious requesters, is the term he uses in his bill, modeled after a law, loosely modeled, I think, after a law in Connecticut, where they have a vexatious requester provision, which does not get used very often, but is on the books and available to agencies. In fact, Nathan, have we heard anything further from Connecticut? Last I heard, they had one case pending under their vexatious requester law, and it had not yet been decided. Is that still the status, to the best of your knowledge?
That is still a status to the best of my knowledge.
All right, very good. All right, Nathan and Charles, I'll direct this one to you and anybody who's with us still. We are running late. I appreciate you sticking with us. We won't be offended if you have to leave. We do plan to make this available on YouTube, and panelists, you have gone above and beyond. If you need to leave, feel free to excuse yourselves. I won't be offended by that either. I appreciate your time. Nathan and Charles, what personal information on a right to know law form, for example, name and address, etc., what of that information is optional for a requester when they are filling out a right to know request form?
I don't think there's a requirement that they put in their home address. I think they just need to give us some method of contacting them. A lot of them just give us an email.
That's a question we get periodically. We do have a standard request form. It does ask for a lot of information. It is better, I think, whenever you can, to provide the agency with multiple forms of contact, because it eases communication, and communication in the right to know process can be absolutely key on both sides. But as Charles just said, having a method for them to communicate with you and provide the records is generally going to be enough. And now we're going to get into some of what I described earlier as the OOR procedural questions about the OOR process. So Charles, some of these will be for you and Nathan as well. What procedure should a requester follow if an appeals officer, so that's the OOR's appeals officer, does not copy all parties on communication, which should be done, and repeats this error during the appeal process?
I think I'm familiar with the case you're talking about. I'm not sure. I'm not sure about the exact details of it. The appeals officers should copy all the parties. There may be an additional party that somebody wants to have copied that the appeals officer doesn't feel the need to copy. I personally, have no problem adding in an extra email address into an email.
Yeah,
but
just
at minimum, just counsel.
Yeah, and just to add to that, I mean, if that happens, I would reach out to the appeals officer and alert them to the error and not copying the other party if that should happen. Especially as of late, we're dealing with literally hundreds and hundreds of emails, so it's good to bring that to the attention. I'd also point out that just copying the agency counsel is sufficient, because the agency counsel is standing in the place of the agency. You don't have to copy the agency necessarily if you are notifying the attorney. That's the attorney solicitor that's representing the agency.
Thank you very much. Charles, you handle a lot of our petitions for reconsideration. In one appeal that this person, I don't have names attached to the questions the way it's in front of me here, but in one appeal, the appeals officer failed to address a particular thing. The attorney filed a petition to reconsider. It was answered within 4 days. In another case, we've been waiting for 9 days. How does the OOR handle petitions for reconsideration and the timing of the petition for reconsideration? And is the process taking longer since this requester is not represented by an attorney?
We typically, the bottom line is we want to give them time to file an appeal if they don't get a grant of reconsideration. We have an internal process of trying to get it out within 15 days of receipt. Sometimes we might not get it until the 15th day. So we try to we try to do our best to get them out. I would say most of the reconsiderations are denied because they don't. A lot of times people want to submit new evidence, and we can't take new evidence on reconsideration. If they raise a legal issue, we may grant reconsideration just to see if we should have addressed that legal issue.
That's an excellent point about not being able to take new evidence on reconsideration. It is so important, particularly for agencies, because they bear the burden of proof in this process, but also for requesters to make sure that whatever you have, whatever you want to present, get it in front of the OOR. If it's a Commonwealth agency that's involved in the appeal, the statewide appellate courts have taken a dim view of taking new evidence further up the chain. If it's a local agency, courts of common pleas are more used to taking evidence in the first place, so they seem more open to it. But there's no guarantee that they will. I'm not entirely certain that they would have to. If
I think another point for agencies to remember is if they're under a time crunch, contact the appeals officer, see if they can get some additional time, to submit evidence. And we train our appeals officers to be very judicious and very circumspect, and try to work with the parties.
And I was going to say, and to add to that, appeals officers are not going to treat parties differently based upon whether one's an attorney or one's operating pro se, representing themselves before the Office of Open Records. The only time that might come into impact is when the Office of Open Records is waiting for additional information from some of the parties that haven't submitted evidence or arguments that they wanted to or wanted to get. The appeals officer may extend it a little bit.
Right. And I will add to that. Thank you, Nathan. That, I don't know, 90%, maybe more of the requesters who file appeals with the Office of Open Records represent themselves. They don't have attorneys. They are pro se. And in my view, it is absolutely unacceptable to have any bias toward parties represented by attorneys in the right to know process in front of the OOR. It's absolutely unacceptable. So if folks think that's happening, feel free to contact me directly. My email address is on our website, and I want to know about it. I don't believe it's happening. I know our appeals officers are extremely professional and aware of that fact, but if there's a sense that it's happening, if it's even just a sense, I want to know about it. All right. We had a question that asked why the right to know law allows private for-profit companies to request data through the right to know process, tying up staff time for the purpose of repackaging and selling that data. I'll tackle this one. When we wrote the right to know law back in the 2007-2008 legislative session, Senator Dominic Pileggi was the prime sponsor, and when we were putting it together, we didn't have any real conversations about how significant the number of commercial requests would be. Our data every year in our annual report or our annual survey of arrows shows that it's somewhere between a quarter to a third of all requests are from commercial requesters. And there is legislation. Many people have bills in on this topic, Senator Blake and many others, which would allow agencies to charge for the staff time when responding to commercial requesters. I think there's case law indicating that you would run into some pretty significant federal First Amendment issues if you tried to prohibit commercial requests entirely, but we do believe that there is an ability to set a different fee schedule, so to speak, for commercial requests, and that legislation to do that is pending. All right, let's see here. We have more questions about the OOR. And I will go to this one here. To whom does a citizen turn or file a complaint or report if a local government does not post its right to know policy on its website? In short, who enforces access to the policy? Whenever we are made aware that an agency doesn't have the policy posted on its website, which is required, as this question implies, it is required by the right to know law to post it on your website. We send them a letter. I sign it, we send it out. And to my knowledge, every time we've sent that letter, the agency has subsequently complied. So there's no specific fine, there's no specific penalty that attaches to not doing that. But I think, as you've heard throughout today's discussion, agencies by and large want to do the right thing, and that's the approach we've taken. Does anybody else have thoughts on that one?
I would just add to that, the times we have done that, it's typically been either an technical glitch somewhere on the website or just a innocent oversight by the agency. I don't believe we've run across a situation where there's been an intentional refusal to follow the right to know law in that aspect.
Thank you. I missed one Sunshine Act question earlier. Melissa and Scott, maybe this is for you. For Zoom meetings, is there a minimum amount of advance notice for the Zoom link itself, where that link has to be provided in advance? And if so, where must that link be advertised? All right.
I've got to unmute Scott. I'll let him go first and then I'll go ahead, Scott.
Yeah, sorry about that. I had muted and away we go. I'm not aware of anything in either in Act 15 that requires a specific amount of notice. I will say that a lot of the agencies, after some of the initial reports of people inappropriately popping in on virtual meetings, what a lot of the agencies were doing is just directing in their ads for the public meetings, directing people to contact somebody with the local agency who would then provide them with the link, as opposed to advertising the link in the ad. I'm not aware of any situations where that wasn't being done in a timely manner. But again, I don't think there's anything specific that would say it must be done X hours or minutes before a meeting.
Yeah, I agree with, I don't think there's a specific, I don't think the laws, Act 15 or the Sunshine Act, specifically address that particular issue. But I think a good rule of thumb is at minimum 24 hours in advance.
Thank you. All right, I've got a small number of additional questions here. I know some more questions have come in by chat. In fact, one of them here at the bottom, it's easy for me to see, so I'll tackle that real quickly. If the agency ARO is not aware via their legal counsel and the OOR appeals officer allows the ARO not to be copied on all communications in an appeal, I think the situation is that the counsel is being copied on all communications, but the ARO is not. How does the OOR know that the ARO has been informed of their statutory duties? I think the short answer is we don't directly know that, but it is the obligation of the legal counsel representing them to make sure that that is happening.
Informed.
Probably won't be the legal counsel for very long if there's any issues in terms of passing that information along.
Right, and certainly a good argument could be made that they should not be. All right, a couple more about the OOR process. In docketing in an appeal, when we docket an appeal, how does the OOR automatically know from the moment of docketing to include a local agency's legal representation if that counsel is not on the alternate ARO list and had not made their appearance known to all parties in the appeal? I think the short answer is we are omniscient and we know everything. But a more serious answer is that our database includes previous cases. So when there are previous cases where an agency has been involved, we often are able to load contact information in there. And if for some reason the counsel has changed since that previous case, they'll let us know. But in an effort to be as efficient as possible, we include as much as we can when we send out the appeal packet, making sure that as many of the right people as possible who need to see it as quickly as possible. We only have 30 days to issue a final determination unless the requester grants us an extension or there is some issue of due process, for example, that comes up, which is rare, but I think that's the answer there. Considering the fact that only 3 cases in the history of the right to know law have been awarded sanctions, and one of those is still being determined by the Supreme Court, do you foresee any legislative changes being made? I think we've talked about this a little bit. This question goes on to say the cost of litigation can be overwhelming to a requester, and because of this, law itself has lost its teeth. There is very active discussion going on in the General Assembly. Again, I'd point you as at least a very good starting point. I wish I remembered the bill number, but Representative Topper has a bill in the State House which does 2 things. It deals with attorney fees for requesters in certain circumstances, and it deals with vexatious requesters in certain circumstances as well. So that is an issue that is known and that folks are actively looking for a way to address. And I think the last question that we'll tackle today, since we're at about a half an hour past now, is this one. How did the OOR find local agencies in bad faith in the past, but at the present time, the OOR now reports that they cannot find an agency in bad faith? And what criteria does the OOR use in determining whether an agency is acting in bad faith? I am surprised. I'm not sure what's being referenced when it says the OOR now reports that they cannot find an agency in bad faith. Please, whoever asked this question, if you're still with us, send me an email. I'd like to know more about that.
We can't award sanctions for bad faith. That only.
I'm sorry, Charles?
What's that?
Could you repeat yourself?
We typically will say we can't award sanctions for bad faith.
That might be what they're referencing. Thank you. Right. The OOR has no authority to sanction an agency. We cannot impose a fine. We cannot sanction an agency. What we have done occasionally in the past is issue a finding of bad faith. And in determining whether an agency is acting in bad faith, so far, it is just a handful of cases. Again, most agencies, reasonable minds can disagree, but most agencies are trying to do the right thing. And the cases where we've done that have always been in cases so far. I'm not saying this is an exclusive list, that this is the only circumstance where we would do it. But so far, it's always been a case where the agency ignored the request and ignored the appeal and did so repeatedly. And when a pattern like that develops, I think that there is no question that the agency is operating in bad faith. When we see an agency ignore a request and ignore an appeal, particularly if we see it happen a second time, I send them a letter and I send it to the head of the agency and say, here's what has happened. Here are the OOR docket numbers. Please be advised that a continued pattern of this kind of behavior could result in the OOR issuing a finding of bad faith. It could result in the agency being sanctioned by courts for bad faith, that sort of thing. We haven't done that quite so much this year during the pandemic, given the unusual circumstances that everybody's been facing. We have, when it is apparent that the pandemic was the cause of a delayed response by the agency or some other kind of timing hiccup happened where a request might otherwise be dismissed for being untimely, being filed too late. We've taken a look at those cases on a case-by-case basis, and where it's evident that the pandemic played a role in that happening, we've tried to docket as many of those as we thought we could and get to the merits of the case rather than dismissing them on a technicality. So, all right, with that, I want to thank everybody for joining us today. Tom, Melissa, Scott, thank you guys so much. We really appreciate you being here. Do any of you have any final thoughts you'd like to share?
Oh, just thank you so much for having us.
Thank you very much.
Yeah, thanks. been great.
Fantastic. All right. Thank you so much. And again, if we didn't get to your question, I do apologize for that. openrecords@pa.gov is the email address to use to send them in. Our website is openrecords.pa.gov as well.
Eric, I think we have one last question, which can be answered easily from Janet. You would have a right of appeal to the Commonwealth Court from a decision of a local court of common pleas.
Right. So, right. If it's a local agency that's involved, the OOR's decision can be appealed to the Court of Common Pleas.
Right.
The Court of Common Pleas decision can be appealed to the Commonwealth Court.
Absolutely.
Very good. Excellent. All right. Thank you all so much. Have a great afternoon, everybody, and we'll see you soon, I hope. The OOR does have regular training sessions by webinar these days, so be sure to check our training schedule. Many of them are equally suitable to agencies and requesters, so there might be something coming up that you're interested in. Thank you all very much. Bye-bye.